What is pure comparative negligence in Utah, and how does it impact my auto injury claim? Attorney Ralph Petty explains that. In Utah, comparative negligence is based on the relative liability for a crash between the drivers. That means that if you are 50% liable for a crash or more, then you will receive no recovery. If you are less than 50% at fault, then you can receive a recovery, but it will be reduced by the percentage of fault for which you are liable. For example, if you were 40% at fault for causing a crash, then you would receive 60% of your medical expenses and damages. So, comparative negligence means comparing the amount of fault between the parties, deducting the percentage of the fault for which they are liable, and awarding that portion of the medical expenses and damages to the least at-fault party. In Utah, there is no fault auto insurance, which means that your own auto insurance company provides a fund of at least $3,000 to pay for your medical expenses, regardless of which driver is at fault. If the medical expenses caused by the crash exceed $3,000, then you are entitled to pursue the other driver to recover your damages and medical expenses. If your medical costs do not exceed $3,000, then you are blocked from suing the driver at fault for your damages and medical expenses, unless you have permanent injuries or scarring. Call attorney Ralph Petty in Salt Lake City, Utah for a free strategy session today. The law office of Ralph C. Petty has been confidently and skillfully assisting clients with their legal needs since 1981 and is not afraid to fight for you no matter what it takes.